Good afternoon, everyone. My name is Maya Luria with TMC for Seniors, and we're continuing on with our Women's Health Month. And today we're going to be discussing legal issues for women. I have Shanelle Schmitz here. She is an attorney with the law office of David Karp. Shanelle has spoken for us many times before, and she always shares so much good information that we need to know. So I want to welcome you here, Shanelle.
Thank you, Maya. It's great to be here. And like I was saying before, it's great to see everyone here as well. As Maya was saying, my name is Shanelle Schmitz. I'm an attorney here in Tucson. I focus my practice on estate planning. So that would be, is it too loud? Okay. So we're just adjusting the volume of the mic for just 1 second. And so I do estate planning. So I do wills, trusts, powers of attorney documents. I also do guardianships and conservatorships for incapacitated adults and minor children, and probate and trust administration. So I help families when their loved ones have passed away, helping them figure out what the next steps are. And my contact information is here. So since the last time I've been here, I have joined a new firm. I'm with the law office of David Karp. I'm very excited to be part of his firm. That's my new contact information. Please feel free to reach out if you have any questions about the presentation. As they were saying, I do have time to answer questions at the end of the presentation from online as well as in person, and I'll stick around for a bit afterwards as well. And so since I'm an attorney, of course, I have to have a legal disclaimer. So the legal presentation the legal information presented in this PowerPoint should not be construed as formal legal advice, nor the formation of an attorney-client relationship. If any results are set forth within, please know that those are based on the facts of that particular case. So is it too loud still? Okay.
It's too loud.
Okay, let me go ahead and move it, because I could hear that feedback a little bit as well. Is that better?
Fine for me.
Okay, perfect. Just let me know if anyone can't hear me now. So it's always just important to contact an attorney with your specific situation to get legal advice that's tailored to your needs. So as I was planning the presentation today, what I was trying to do is come up with common concerns that I hear from clients who are women. And a lot of the common concerns are they want to make sure their family is protected. So some of the concerns I hear are about family dynamics, their relationships. A lot of my women clients are the ones that are holding together. They're like the glue of their families. And so they have concerns that after they pass, what will happen? Will it be easy for their spouse or children? Will there be any disputes? Will there be a smooth transition? They also have concerns about protecting vulnerable spouses or just their spouses in general. They may not be vulnerable right now, but they may become vulnerable. So that is a concern as well. And also protecting children's inheritance. Another common concern that I hear from women clients is they tend to be in the role of caregivers, whether it be for incapacitated spouse. So when I say incapacitated spouse, I'm talking about those incapacity in terms of like Alzheimer's or dementia. So maybe they're caring for their spouse who has Alzheimer's or dementia, and they're having to make all medical and financial decisions. Also special needs adult children. A lot of my clients who have special needs adult children who are caring for them are women. So they want to make sure that they're protected if something happens to them. So if they become incapacitated or upon their death, they want to make sure that there's some kind of protections in place. And also, sometimes my clients have adopted their grandchildren and they're raising their minor grandchildren. So we'll go over some ways that you can prepare for these concerns. Another common concern is planning for incapacity. So statistically, men tend to die younger than women. So a lot of women end up finding themselves in a position where they're widowed, or maybe they don't have any children, or they don't have family or friends that they trust to make medical and financial decisions for them. So we'll go over certain tips and tips for your estate plan that would help you address these concerns. So I get the question often, what is an estate plan? And a lot of people don't really understand what an estate plan is, or that everyone should have an estate plan. I hear a lot of people say, well, I don't have an estate. I'm not rich, I'm not wealthy. Why do I need an estate plan? But there's a lot more to an estate plan than just managing your assets. So these are the essential estate planning documents. And as we go through them, I'll address those common concerns and give you some tips as to how to address those concerns. So the first is a will. Most people are familiar with a will, and we'll go over that a little bit more. There's also a living trust. A living trust is not for everyone. Not everyone has it. Not everyone needs it. If you do have a living trust, you're still going to need a will, and that would be a pour-over will. A durable financial power of attorney, healthcare power of attorney, a living will, which is also known as an advance directive, and a HIPAA authorization. So a will. So a lot of people don't understand that a will is only effective upon your death. So if you become incapacitated, the will's not going to have any effect. It doesn't plan for incapacity. A will is essentially instructions to the court as to what you want to happen with your assets when you pass. So it names a personal representative or an executor, but the idea is it does go through court, so requires probate. Probate court is just a special court that handles these types of situations, so it requires probate to work. So within your will, you can address some of those concerns. So a lot of people know that you can name a guardian for a minor child in your will. So if you have adopted a grandchild and you're concerned about what happens to their care after you pass, you can appoint a guardian in your will so that someone is in place. So you're telling the court who you would want to make health and placement decisions for that minor child. Now, a lot of people don't realize that you can also name a guardian for an incapacitated, unmarried adult child. So a child with special needs who is not going to ever be in a position to make their own decisions. You can go ahead and name a guardian in your will so that there's a continuance of care if something does happen to you. You can also name a guardian for an incapacitated spouse. So if your spouse has dementia and Alzheimer's and they're not going to be able to make decisions in the future, then you can go ahead and name a guardian in your will for that incapacitated spouse. So that helps make sure that there's a continuation of care and a plan in place. So if something happens to you, you're addressing the concerns about making sure they're taken care of. A trust. So what is a trust? So think of a trust as like a bucket, and you're creating the bucket today and you're putting all of your assets into the bucket. So it's actually effective while you're alive. So remember, a will is only effective after you pass. A trust is effective while you're alive. So you are the trust maker. Usually you're the trustee, so you're in charge of whatever those assets are that are in that bucket, and you're the beneficiary while you're alive. Within the trust, you're naming who you want to manage those assets for you if something happens to you. So if you become incapacitated, who's going to pick up that bucket and manage all of those assets on your behalf? And you're essentially providing instructions for your trustee as to what you want to happen. And the idea is to transfer all of the assets that you can into your trust. So during life, like I said, you have incapacity planning because it is effective while you're alive. So within your trust, you can actually provide instructions for how you want your assets to be handled if you're incapacitated. So let's say you have a special needs adult child and you want to make sure that child is taken care of with your assets as well. If you become incapacitated, you would provide those instructions in the trust so that that can happen if you do become incapacitated. And the trust also applies after you pass away. So the idea is your trustee picks up that bucket and does whatever the instructions are with those assets in that bucket. Now, a lot of people focus on what they want to happen to those assets when they pass, who they want those assets to go to. Trusts are very flexible because you could actually provide protections to your beneficiaries within the trust. So some things to consider. So like I said before, some concerns are protecting your children's inheritance. So if you're married and you're concerned about your spouse changing your estate plan after you pass and disinheriting your children, which unfortunately happens, You can have remarriage protections within your trust. You can also have beneficiary trusts set up within your trust to provide the beneficiaries with protections. So remarriage protections. So this is just to kind of lighten things up a little bit. This is Elaine. Elaine is your husband's next wife. In the month since your death, she's brought home-cooked meals to your husband 6 times. Each time she visits, she wears a skimpier outfit. She cannot wait to redecorate your home. She thinks that there is no good reason that the money earmarked for your children shouldn't be spent on her, on more important things like jewelry, sports cars, European vacations, and of course her children. So one thing to ask yourself whenever you are setting up a trust is if you would want someone like Elaine to have your assets after you pass. Some people don't care. Some people are like, I'm dead, why does it matter? So then you don't have to worry about setting up special protections. But if this would bother you, then you can go ahead and have remarriage protections in your trust. Some things that you can do is have a prenuptial agreement requirement for a prenuptial agreement, so that if your husband were to get remarried, those assets are protected from someone like Elaine. There are different ways to set up your trust to leave your assets in a way that is protected from someone like Elaine taking your children's inheritance. Now, you also want to make sure you're protecting your children. And not a lot of people think about ways to protect their children. So this is your son-in-law, Fred. Fred hasn't had a job since 1999. You suspect he is very fond of chemical substances. He thinks it's great that he has rich in-laws, and he always seems to be checking out other women, even in your daughter's presence. So would it bother you if you leave your money to your daughter and Fred eventually gets half of that money? So that's something to consider when you are setting up your estate plan, because you can set it up in a way that you leave it in a trust for your daughter so that Fred wouldn't have access to those funds. So those are just some things to consider as you're setting up your estate plan. Now, again, some people don't care. Some people are of the opinion that their daughter made the decision to marry Fred. It's on her, she's an adult, but other people it would bother them. So it's just something to consider when you are setting up your estate plan, because most importantly is to make sure that your estate plan works for you and it addresses your specific concerns. And there are options if this is one of your concerns. So the next document is the durable financial power of attorney. So that is effective while you're alive. And it's going to cover all the assets that are outside of your trust. Or if you don't have a trust, then it covers, all the assets that are outside. You can have disability protection. So if it's durable, it would still be effective if you became incapacitated. And I typically recommend to my clients to have very broad powers. Our philosophy is sweaters in a suitcase. Some of the sweaters you definitely will need, some you may need, some you probably won't need, but at least they're in that suitcase. So our power of attorney is very broad in the sense that it is around 30 pages long, but it does have a lot of powers in there. So if something's needed to happen, like if someone needs to file taxes on your behalf and you're incapacitated, or collect your mail or care for your pets or apply for government benefits, it's within that power of attorney. So it's good to have a power of attorney in place. Now, it is a great responsibility and liability for the agent. So you want to make sure that you're choosing someone that you trust. And in any of these roles, that's the most important thing, choosing someone you trust. Now, one of the problems with financial powers of attorney is it's not always accepted by financial institutions. So when that happens, sometimes a conservatorship is needed. What I usually recommend to my clients is if you don't have a trust set up and if you have assets outside of your trust, to make sure to update your power of attorney usually I recommend around every 2 years, 1 to 2 years. You can also go to the financial institutions, and they usually have their own form power of attorney that you can fill out as well, just as another precaution. But if it weren't accepted, then a conservatorship would be needed. So it is important to nominate who you would want to serve. A conservator is someone who's appointed by the court to manage your assets if there's no other legal authority to do so. So it's important that you appoint someone who you trust and tell the court, this is who I want. Otherwise, the court goes based on priority laws under the statutes. So it's good to have a voice in those decisions. The next document is the healthcare power of attorney. So the healthcare power of attorney is very important. So it's nominating who can serve as your healthcare agent. So who do you want to make your healthcare decisions for you if you're not able to do so on your own? The agent does not have to be your spouse or your children. Sometimes my clients feel that they have to do their children by birth order, and that's not always necessarily the best way to go. It's really who you trust to make those decisions for you. So if your oldest child wouldn't be good at making health decisions, or at least following what you want, if they're in that position, then you probably shouldn't put them as your first option. And if you don't have any family or friends, so like I said, sometimes women find themselves in a situation where maybe they're widowed and they don't have children, or they just don't trust their spouse, or maybe the spouse has capacity issues, or they don't have any other family members or friends to serve. There are other options. So in Arizona, there's professional licensed fiduciaries who can serve. What I usually recommend to my clients is that they meet with them and develop a relationship with them, because it's very personal. Just like estate planning is very personal, you want to make sure that you're comfortable with your estate planning attorney. You also want to make sure that you're very comfortable with your fiduciary, because they're going to be stepping into a position where they're making very important decisions for you if you go that route. And within your healthcare power of attorney, you can also nominate a guardian. So you can specify who you want to serve as your guardian if a guardian were ever needed for you. You can also specify who you do not want to serve. So a lot of times when I'm meeting with clients, I'm talking to them about not only what they want to happen, but what they don't want to happen, because we want to make sure your plan addresses those types of situations where if maybe you don't trust your children to make the right decisions and you would never want them to make healthcare decisions for you. You can put in your documents that you don't want them to ever be appointed as your guardian through the court. You can also include funeral and disposition arrangements, and you can also have mental health powers. In Arizona, what that means is if you allow them to have mental health powers, your agent could have you placed in a locked psychiatric facility. So that's a lot of power. So you really want to make sure that you're comfortable with whoever you're putting in that role. The next document is a living will. So again, it's living will, living meaning it comes into effect while you're alive. So what it does is essentially says whether or not you want life-sustaining treatment beyond comfort care, if there's nothing else that the doctors can do for you. So if you're terminal and irreversible coma and the doctors say there's nothing else we can do, whether or not you would want life-sustaining treatment. And you can also have a pregnancy override in it as well. Another document, I'm sure a lot of you are familiar, HIPAA authorization. I usually recommend to my clients having a separate document along with having the HIPAA authorization within their healthcare and financial powers of attorney. But the separate document allows you to put people who you would like to be able to get updates on your health situation, but maybe not necessarily make healthcare decisions for you. So like if you have a daughter that you wouldn't trust to follow your wishes and make those decisions that you want, but you want her to have access to your healthcare information, then you would list them on your HIPAA authorization. So some potential problems faced by women if they don't have an estate plan in place. And again, when I was going through this and trying to figure out what concerns are for women, it's not saying that these don't apply to men as well. I was just trying to come up with the concerns that I hear often from women clients, or that I see often when dealing with women clients. So if you're not legally married to your significant other, so let's say you've been with a partner for 20 years. Arizona doesn't recognize common law marriage. So if there's no estate plan in place, you have no right to your significant other's property. So if you're living in their house, you've been living there for 20 years, they pass away, they don't have it set up where the house goes to you, then you may be in a situation where you're having to move because you don't have any right to stay in the house, or you don't have any right to that property. So it's very important not only to think about having an estate plan for you, but making sure you're protected as well. Now, you also wouldn't have any decision-making rights under the law. So you wouldn't have any rights to make healthcare decisions, financial decisions during incapacity, or even funeral arrangements. And this, unfortunately, I've had to deal with this situation quite a few times where a client comes to me and they say they want to handle funeral arrangements a certain way, and they have no say, and they're wanting to know what they can do. And unfortunately, if there's no estate plan in place, it's very difficult because they don't have any legal rights. Another potential problem faced if you don't have an estate plan that we see often is with blended families. So if you're in a blended family, it's very important to have an estate plan in place. And when I'm talking about blended families, I mean, like, let's say you're married and your husband has 2 children from a different relationship. So that would be considered a blended family. So if there's no estate plan in place and your husband passes away, not all of his property is going to transfer to you. So his children will get his half of the community property and half of his separate property. So you could be in a position where you're having to move out of the house and you're having to sell it and split it with his children. And unfortunately, sometimes in blended families, especially after death, when emotions are very high, there's a lot of tension and disagreement. So you want to try to prevent being in that type of situation. The number one mistake is probably, in my opinion, not having an estate plan in place. So if you don't have an estate plan, Arizona laws essentially say what's going to happen. So that's why it's very important to have a voice in what happens if you become incapacitated or when you pass away. And estate planning is necessary, but not always urgent. So this is the 90-day Think About It program. So if you're going to just think about it and think about it, the law doesn't recognize that you're thinking about it. So it's good to just try to get that set up. And so now I'll open it up to any questions.
We'll start online.
So thank you so much, Shanelle. So I do have a question just about how do you protect yourself from being taken advantage of, financially or legally, especially if you've begun to experience some sort of a cognitive decline as you age? What should be those steps that you've taken, to get ready for something?
That's a great question. So I don't know if everyone could hear, but the question is, how do you protect yourself if you're starting to see you're starting to feel some mental decline and you want to make sure you're not vulnerable and taken advantage of? So what I would say is definitely talk to an attorney about getting an estate plan set up, because they can go over those different, you want to have an estate plan that addresses not only when you become incapacitated, but also upon your death. And they can go through different ways that you can protect yourself. So sometimes, like I was saying before, sometimes clients are concerned about their family members. They don't necessarily trust that they won't take advantage. And unfortunately, I do see a lot of family members taking advantage of vulnerable adults. So in that situation, if you have concerns, it could be a good idea to have a professional in place. So not only are there licensed fiduciaries, but there are also professional trust companies as well that I work. There are some that I've worked with often. So like I said, I do try to have my clients meet with them first before they put anyone in that role, because you have to be comfortable with who you're having in that role. But with like trust companies, for instance, there's certain audit processes to try to avoid you getting taken advantage of. So sometimes it is a good idea to have a professional in those roles. And licensed fiduciary you can have in the role of healthcare agent. So if you don't trust your family members to make those healthcare and placement. And when I say placement, that's also like where you're living. So if you're living at home versus in a facility, if you don't trust your family to make those decisions or friends, a professional is a good option.
Okay. And can you talk a little bit about having somebody in place for your healthcare directives? Just what should you do? Like, what does that process look like, right? They complete their documents, but also just what do they do afterwards, right? Where should they store them, and who should they share that information with?
That's a great question. So the question is, what happens? So if you have your healthcare documents in place, what happens afterwards, and what should you do with your documents afterwards? So it's always a good idea to talk to your healthcare agent and let them know what your wishes are and have those conversations with them. Because if you just name someone and you don't tell them what you want, they're not going to know what you want when they have to serve. So that's always something I recommend, sharing a copy with them if you're comfortable. Another option that we do give to our clients is there's a program called DocuBank. So it's not something that our office does, but we work with the third-party provider where you essentially upload your documents to DocuBank, and they provide you with an emergency card that has your emergency contact information on one side and a PIN number on the other. And so if you were in an accident, the idea is to keep it behind your insurance card in your wallet, and hopefully the hospital will find it if no one else is there to be able to tell them who your agent is. They can call your agent, and they can also access your healthcare documents using that PIN. Now, there are other options as well besides DocuBank. There's the Arizona Registry for Healthcare Documents as well. So that's also an option too. You can upload your documents there, and that way there is that access to them.
And I think it's important for folks to know that if somebody is looking for those documents, we do have them available here at TMC for Seniors, and we have someone who can help them to complete those documents too, if they need it, just for your healthcare power of attorney. But then through your services, Shanelle, do you, I guess, if somebody is not sure about the financial component of having something drafted, are there other alternatives that somebody can do?
Yeah, so sometimes attorneys are expensive, and I don't want anyone to feel like you can't have an estate plan in place. So for, like Maya was saying, I think it would be a great option to get your healthcare documents filled out or get assistance here to fill those out. So I'm assuming they probably use the Arizona state forms. So those are also available online at the Arizona Attorney General's office. So it's usually the healthcare power of attorney, the mental health care power of attorney, the living will. So that is a great option as well.
Yes, thank you. And I'll let you open that up to questions in the audience.
Does anyone have any questions? Yes.
How do you find a licensed fiduciary?
So the question is, how do you find a licensed fiduciary? So Arizona, I believe it's on the Arizona Supreme Court website, and there's a list of licensed fiduciaries here in Arizona. So the list also has their addresses, so you should be able to determine whether or not they're here locally in Tucson.
Where was that site again?
I believe it's on the Arizona Supreme Court website.
And there was a cost involved, of course. Is that expensive?
It depends. So typically I'm finding most licensed fiduciaries, the question was if there's a cost involved. So typically I'm finding most licensed fiduciaries charge somewhere around $75 to $125 an hour. Most of the time they're not charging anything until they're actually serving. Some do have like a small fee to get set up with them. So you'll have to talk to them. I think typically what I'm seeing is the fee is around $300, but not everyone does. So you can find a licensed fiduciary who you don't necessarily have to pay up front. They'll just get paid after they start having to serve. Yes?
What can you expect to pay for one of these estate plans? Is there a range of prices starting at?
So it depends. So at our firm, typically, so we're very thorough. So we also help with funding assets into the trust as well. And we also help with a few other things. So typically for a trust, if you're having all the protections that I discussed, you're looking at the range of somewhere around $5,000. For wills, it's probably half of that, but it all depends. It's going to depend on your specific situation as well. Yes.
Saying that it's 5,000, when if you're on Social Security, I mean, there's no way that you can come up with 5,000.
Right, and not everyone's going to need that extensive of an estate plan. So, there are other options. So that would be like the full service trust
Okay.
package. So there are a lot of other options. So typically for like a will-based plan, you're looking at, I'd say somewhere around 2,000, and that's so whenever I'm saying that, that's including all of the documents and as well as helping you set up beneficiary designations. You may not need all of that, so it may be less. And you can find places that'll do like per document as well. But like Maya was saying, there are the free healthcare forms online at the Arizona Attorney General's office as well. So you may not need help with setting those up.
Okay, oh,
And we have copies of those here today,
Um,
if you need it.
when you set that up, I'm 75. Let's say I live to 80, I'm just saying that. Hopefully it's longer, but, are you paying these people, that 5, 6, 7 years?
So the question was, let's say you're 75 and you pass away at 80, are you paying these people for that 5-year period? So typically, no. Typically, you're not paying anyone until you need their services. So like for a licensed fiduciary, for instance, sometimes there's that initial fee up front. Oops, I accidentally turned that off. Sometimes there's an initial fee up front, but usually you're not paying anything until they're actually serving as your licensed fiduciary, and then it turns into an hourly rate.
Okay, so that's when you pass away, that begins.
Or yes, so when you pass away, that's when it would begin if they're administering your estate. If you're incapacitated, then they would start charging that fee once they take over your assets and start managing everything for you.
Okay.
And so yes, there's a
How often should you have your trust, the documents reviewed?
So how often should you have your trust documents reviewed? So that's a hard one. So so part of our firm, so that, what I was talking about in terms of prices, that also includes a client care program. So we try to get our clients in every year and we follow up with them. A lot of times I see people kind of not updating their documents for 10 plus years. And so things have changed substantially. So it's a good idea to, I'd say, try to get a review every couple of years it'd be great every year, but if you can't do that, then at least every couple of years.
Thank you.
Can you hire another attorney to review your existing documents to see if they're really complete or?
Yes. So the question is, can you hire another attorney to review your existing documents? And yes, you can. And I think that's actually a great idea to do it because some attorneys have different approaches. Some focus on just where your assets go, some focus on protections, and you want to make sure that you're setting up your estate plan how you're wanting it.
And my second question is, if you have no arrangements, who's gonna bury you? Or
So-
whose hours of burial then?
So if you have no arrangements, who's going to bury you? So I guess it's going to depend on the situation. So there is a law in Arizona that kind of defers to certain family members. I don't know it off the top of my head. I'd have to look at it, but I believe it's spouse and then children have that authority. But it's good to, I think the Arizona healthcare documents online, I think they allow you to, or I think there's a provision in there specifying that they have the authority. So it's good to try to have that set up. Yes.
When you talk about reviewing, does that have to do with the laws changing or just your different decisions being made?
So the question is, when you're reviewing a trust, is it just about the law changing or is it different decisions? So it depends. So sometimes the law is going to have changed. So like we had a substantial change a couple of years ago with how IRAs are dealt with. So sometimes it is a law change. Sometimes it's also a family change. So maybe you have new grandchildren, or maybe you no longer like your son-in-law, and you want to set up your trust in a certain way. So it's good to just review it, because a lot of times I'll get clients coming in with a will that's 20 plus years old and they don't even know what it says. So it doesn't reflect their wishes now. Maybe it did at the time 20 years ago, but it doesn't necessarily reflect your wishes now.
So is this all common, is this maritime law, under maritime law?
So the question is this under maritime law? So I don't, so it's under Arizona law. So if you're here in Arizona, it would be based on Arizona law is what I would be looking at. So if
But
you,
isn't all the law nowadays maritime law?
not necessarily.
What is maritime?
So I'm not really sure what maritime law is in terms of what you're referring to it, but in
If you're
Arizona,
an attorney under the British Crown, you're under maritime law. The law of the courts are a maritime law. And we are gonna be going to common law in the not too distant future. And I wonder if there are any attorneys in town that know anything about common law.
so in Arizona, there's actually a specific statutes and case law under Arizona law that apply to these situations. So there, sometimes common law does come into play, but most of the time there's specific laws in place that address. So like there's a trust code under Arizona law that address trusts. There's also case law that you would look at. So it's just going to depend. So when we're reviewing an estate plan, we're just looking at how it was drafted previously and looking at how the law is now to try to advise you on whether you should make any updates.
Well, I've been doing business under common law for many years, even though most of everybody does maritime law.
Yes.
Okay.
You
So
can, you
There's
can
a
talk to her
difference.
about that, maybe after one-on-one.
Okay.
Yes, I want to thank you so much for being here today, Shanelle, and answering all of the questions that regard to, legal issues. So we want to thank you for being here today and hope that people will join us next week for more on our Women's Health Month.
great. Thank you, Maya.